We need a 2-minute pause to sort out the technical issue. Just a moment.
I think it's working. Yeah, I can hear you much better.
I can hear you now. All right, so let's call this code enforcement board meeting to order. It's September 1st, 2020, and it's 7:08 p.m. Clerk, can you please call the roll?
Board Member Figuera,
Present.
Board Member Corey,
Present?
Board Member Martinez Figuera.
Here.
I think I answered for Mr. Rubio.
Here. You said Figueroa.
I did. Sorry about that. Board Member Langston,
Here.
Board Member Diaz, Chair Jimenez.
Here. Okay, let's all stand and salute our flag. I pledge allegiance to the flag of the United States, one nation, under God, indivisible, with liberty and justice for all. Okay, should we approve the minutes or the people?
Let's swear Monin. If all members of the public that will be speaking today, please stand up and raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You may sit back down.
Okay, I request a motion to approve the minutes from our last meeting, which happened to be in January 7th, 2020.
I'll make a motion to approve the meetings of the January 7th, 2020 meeting. Second.
Okay. I'm gonna call the roll. Board Member Figuera,
Aye.
Board Member Corey,
Aye.
Board Member Martinez Figuera,
Aye.
Board Member Bankston,
Aye.
Board Member Diaz, Chair Jimenez.
Aye. Okay, so we've already sworn in the people.
Yes.
Do we have any old business that we should take care of now, or should we leave it to the end and?
But old business is case 1, which is a fine reduction,
Okay.
and the gentleman is here. So we can, Officer, please.
Okay, sir, can you approach, state your name and your address, please, for the record?
Robert Avilo, 325 South Drive.
order for a fine reduction. On January the 7th, the case was heard at the code compliance board meeting. Board member Bankston motioned to grant the property owner 60 days to obtain an issued permit or a $50 a day fine is taken into effect. Board member Corey seconded the motion, which passed unanimously on a 4-0 roll call vote. The roll call vote was as follows. Board member Corey, board member Bankston, board member Pineda, and chairperson Jimenez voted yes. So on February the 18th, process number 20-409 was issued, and on 3/27/2020, the permit was issued. $1,000 fine was added on June 19, 2020, per the code compliance board hearing of January the 7th, as the permit was to be issued by March the 7th for their order. Permit was not issued until March 27th, so that's 20 days times the $50 per day equals $1,000. So he came to see me on a fine reduction. He requested the hearing on July the 15th, and he paid the $75. And I explained to him that it probably wouldn't be until September, and here we are. So basically, yeah, he's 20 days past the time frame given.
And if I'm reading the notes correctly from the code enforcement department, the notes go all the way back to July of 2018.
When the case started,
Yes.
yes, July 2018. Thank you.
Is it right that, he got the permit on, February 18th, or at least it was applied for February 18th?
It was applied for, right?
Were there comments and revisions to the permit? And that's why it took a month and a half roughly? Why did it take a month?
I don't have that information with me. I think he might have that.
I do, I have here the first day, first day we came in was February 4th, which was to apply for the permit, which is a permit application I have it here. On the January 29th, we have to go ahead and start with the, I have here, started with the boundary survey, began February 18th was the first day. We went to an engineer, he had to do multiple plans with the city. I guess the first plans didn't go through, he had to do it 3 times, and then the city finally asked for a engineer's drawing for the bathroom as well, which took that long of a time, and we didn't get it till the 27th, March 27th, it was issued, the permit was issued. Me and my wife, we started on the February 4th, it took long to do an engineer, and this is what we are, that's why we're here for the fine reduction.
Okay. So what took you 5 weeks, over 5 weeks to apply?
What
It
took
was for a bathroom?
From the set, what was that?
It was for the bathroom,
Bathroom and the front porch.
the front door,
Front porch. Porch.
roof?
No, it was we changed the spindles, but then they had asked us, since anything was touched on the porch, they needed engineer drawings. We didn't know we needed engineer drawings, so we had, that's what.
Okay, so it took you 5.5 weeks and you didn't ask to come back to the board for another week or 2? You didn't ask to come to the board for an extension?
No, I did not.
Okay. I don't have another question.
This case is initially from July of 18, right? It's from the first inspection took place.
There were actually 2 cases. Robert handled the other one, I believe it
The
was
porch.
for the porch. And that one was done on time. And that one was
Yes,
taken care
the other case was done on time because we gave him more time for the porch. We gave him 90 instead of 60 days. So he was in compliance with that order. But he wasn't in compliance with this one because he had 60 days. But but he submitted a permit for both at the same time. So that's why he complied with one and not the other. So with my case, he complied, he won't be coming in to see you anymore. He complied with that.
That permit was pulled and closed.
It's kind of hard for us to do something when you didn't come and ask. You knew you didn't get the permit, we knew we had a meeting, even though we didn't have a meeting, you can still ask for it. I mean, you know, we don't know what's going on with the city, we don't know what's going on with you. I mean, both take time, I understand that, I did it for 4 years. But you have to ask us, we asked you how much, 60 days, which is plenty. Unfortunately, you ran into some problems in the city, I don't know, the city, you know, maybe they're in a move or something. They lost a little time, but I mean, we can't help that or them.
For the next, just to clarify, we can't issue an extension of this because there was an order. So the order needs to be met. So he
You
could
can
have
come
asked
ask
for
us
an
for more time. Everyone comes and asks us for more time.
No, but he had, and the board had decided on an order already.
They can ask for more.
He can come up to the board and give us.
They come out all the time and ask us for more time, and we grant it.
I wasn't aware of that, I started, again, I had this.
Tell them, you can't make it come back, you gotta come ask us, you have to ask us. Right or wrong.
Well, and also, on his part, we weren't able to meet due to COVID-19. Anyway.
I realize that, but he didn't ask either. He didn't ask to come to the meeting more time, he didn't.
Make
We don't know
contact.
that.
Yeah.
None of us
Correct me
knew
if
what
I'm
was
wrong,
going on.
but once an order is done, they have to meet the order, they can't ask for an extension on an order. Council, right?
I have a question.
They can ask for, they can request an extension.
It says, if I'm reading it right, it says January 7th, the case was heard by us, and we granted you 60 days to, get a permit. Just a question for you, why did it take you from January 7th to February 18th to apply for the permit?
Again, I started on the 29th, January 29th, it did take me a couple weeks between work, 2 kids, not an excuse. I started on the 29th with the survey, came in on the 4th, finally got the paperwork on the 18th, I believe, and then the back and forth with the engineer was the whole thing.
Is there a fine levied on, a permit application that resolves a code compliance issue?
Yeah.
There is a
The
fine.
building department does impose a fine.
Okay,
It's double the permit fee plus $100.
so the gentleman's already paid double the fee and $100.
Yeah.
And he made, I think, a good effort. He submitted and showed an intention to comply. Although he should have asked for an extension,
Absolutely.
but I think the intention is there.
And has the permit been closed, final inspection, everything's
Final
good?
inspection goes on.
You know better than to do anything in Miami Springs without a permit. I
Won't
guess
happen
now,
again.
right?
I don't wanna see Mr. Banks.
Or us. A lot of us, we've been here for a long time, so we're very familiar with all the cases.
Do we have anything on the table as to recommendations to lower the amount?
I think the effort was there, okay, and, by the way, when was the last time we met?
January 7th.
That was the last meeting we had.
Exactly. So is there a venue for him to approach us to ask for an extension, as we were talking about?
He wouldn't ask us.
In other words,
he would go to
if-
the city.
If you realize that by March 7th you couldn't make it, what is the option that he has, or is the venue that he has to let us know that he was not going to be able to make it for whatever reason?
You can communicate with the code enforcement officers in the building department. All the citizens have the opportunity to call him whether he knows that or not, which now he does. They're always open to telephone calls and you can, I don't know, you guys give people your email or not.
So just for further clarification, if, not that this will happen, but if something like this were to happen, I would reach out to code compliance and they would be able to grant an extension?
They would not grant, but they would be informed,
Yeah.
and therefore, when we start asking questions, they can tell us, yes, indeed, he did let us know, and, you know, residents do let, and people that get fines and have issues, they do, as long as they're informed, and then we can confirm with them, then it looks good on your part, that you made even more of an effort.
Any recommendations to lower it to a certain amount per day? It's up to $50 per day to cut the amount.
I mean, I think that it's, he's paid double. I mean, in these times, COVID times, I don't know what the situation is. If it's, he got compromised, considering the uncertain times that we're in, he's already paid double the fees, fines, he's paid, you know, in his time. So, I mean, I'd be more.
I'll motion to reduce the, reduce it to $250.
Make a motion,
I think the effort is there.
make a motion.
You gotta make a motion.
I can
He
motion.
did, he said he motioned to reduce it to
I'm sorry, you make a motion.
I
Need a
thought I said
second?
that.
Does
Make a
somebody
motion to
second
reduce it to
second?
$250.
Okay, so I need a second.
Second motion.
We're gonna close it for this.
We don't have to close it for this session.
All right, so can you repeat?
Make a motion to reduce the penalty to $250.
And I have, board member Diaz as a second. Any further discussion for you guys? Jackie?
I was not here for this one, I'm just, a lot of work and a lot of stuff went on here, so. I see a lot of notes whenever I go back to the notes from the code enforcement department.
Do you wanna make another motion?
What I can do is I can take roll, and if it passes, then we go with that. If it doesn't, then somebody else can make another motion. Okay?
Okay.
I don't know how members are feeling about the 250, I don't know if we have enough votes or not.
I'm gonna take roll. Board member Figueira?
Aye.
Board member Corey?
Aye.
Board member Martinez Figueira?
No.
Board member Bangston?
No.
Board member Diaz? Chair Jimenez?
No.
It doesn't. So you guys will, have to discuss again.
Okay.
John, I know you're more familiar with the construction aspect,
No.
so far, yes.
Yes, it's just I can't hear.
I don't-
She says you're familiar with the
I
construction.
said, I know you're more
I
familiar with
just,
the
I
timeline.
mean, there was enough time there, it was before the COVID hit. When I say before it hit, before anything was shut down, there's plenty of time there. I understand we run into things. I don't understand why they don't ask for more time. It's all we do is grant people time. That's the problem I have with it. If you want me to make a motion, I'll make a motion.
Go ahead.
I say we drop it to 500, not that I want to. That's it.
Okay. Somebody second the motion?
I'll second the motion.
Okay.
Want to vote again? Board member Figueira?
Aye.
Board member Corey?
Aye.
Board member Martinez Figueira?
Aye.
Board member Bangston?
Aye.
Board member Diaz?
Aye.
Chair Jimenez?
Aye.
Okay, that's 5-0.
Okay.
Thank you.
Thank you.
Thank
You as well.
It's the case for 210 Law
Lawn Way present. And people for 210 Lawn Way present. So the next one we have is case number 4.
What are we doing with cases that the parties are not here? Are we just giving
We'll
over?
just come back to them after we're done with the people
Yeah,
that are.
okay, I'll start that later. We're skipping, if you could let us know what page the cases are on.
Which case is next?
And what
Case
page?
number 4, and the agenda is 4545 Northwest 36th Street.
And the page number is, I know we're skipping quite a few.
Number 4, on your list over here, it's 36th Street.
What page?
59.
59, 59?
You don't have to stand up for now, just because I'll introduce and I'll make my presentation, and then you can step up to speak. There's 6 people in the party. Are everybody representing the property owner? Everybody's here for the property owner? No, I'm talking about, yes, 5 people. Is anybody representing the tenant? No? The property owner? No. Please, because okay, board, so this is case number 1438, property address 4545 Northwest 36th Street, and the code violation is 9313, maintenance of property by the owner. On June 24th, 2019, a permit application was submitted for the complete renovation of the building. On June 11th, 2020, I received a phone complaint regarding the state of disrepair of the building. On June 11th, at 2:45 p.m., I confirmed the complaint, photos were taken. The property is riddled with graffiti, broken windows, collapsing ceilings and roof, abandoned items, and overgrown weeds. On June 17th, 2020, I issued a civil infraction notice granting until June 25th for them to pay for the pending permit fees for the renovation of the building and start the work. On June 17th, 2020, Mr. Lancaster, attorney representing the tenant, maybe she'll be able to explain later on who these people are, but this is what this gentleman said. He was an attorney representing the holder of a 99-year lease. Called me and explained that they are having issues at the county with the approval of the permits and some legal issues between the property owner and the tenant. I explained that the deadline would still be in place since the property has been a repeat offender of the same code for the last 3 years and has continued to get worse. On August 21st, I issued a uniform civil violation citation number 473 in the amount of $100, sent it via regular and certified mail, and I prepared the summons to appear to today's meeting. On August 27, 2020, I received a call from Mr. Mitchell Davis, who explained that he is an attorney in the firm representing the property owner. He explained that someone will be present today to represent the property owner. So this is the property in 2018.
Robert, I'm sorry, we don't have all of the notes, the bullet points that you were reading from, the name of the attorney you mentioned, Mr. Kenlon.
Yeah, so I added that late. I had prepared, when this was prepared, I had yet to speak to this person.
Okay, what is the name of the second attorney that you mentioned? Who is?
The second
You
attorney
can go back to that,
is Mr. Mitchell Davis,
okay?
and he's in the firm that's representing the property owner.
And is he here today?
He's my associate.
Thank you.
So this is the property in 2018. This hasn't come sooner to the board because permits were submitted to completely renovate and bring the property to a with good, state. And they were going back and forth with the approvals, so, and then sometimes they would come and they would clean up, they would board the windows up, they would, at one point, the air conditioning was falling off the roof, and they went in there, they applied for a permit, and they removed all the stuff that was really loose and could potentially become airborne and hit, one of the neighboring buildings. So those cases were being addressed, individually, but the building has gotten worse and worse with time.
Is it structurally safe?
Currently, it's not considered an unsafe structure because there is a fence barrier around the property from Miami-Dade County unsafe structures. As long as there is a barrier around the property where nobody could go in, it's not considered unsafe. Obviously, the state of the building is an unsafe structure. Nobody can perform business or provide a service from within that building in the state that it is. This is in May of 2019. This is in June of 2020. So these are pictures that I took last Friday. The fence fell off the gate. It doesn't seem like it might have fallen off. It seems like somebody might have propped it open. We are receiving complaints of homeless people around the area. Yeah, these photos are not in the packet.
Okay,
Because when the packet was created, I hadn't been out there yet.
thank you.
And if you want me to go back to a particular photo or get a closer look, if you're hoping to come.
I think we're getting the idea of the state of the building. I noticed that we're mentioning a tenant, here. The citations have been issued to the owner, and ultimately the owner is
Well,
responsible.
the property owner is listed on everything has been issued to the person and entity listed on the property appraiser's website.
Okay,
I am not entirely sure if that's the property owner or not, because based on some of the conversations I've had with the attorneys, there's a big story behind this particular property. Apparently there is a 99-year lease, and some stipulations were done in the lease where some of the responsibilities fell on the property owner.
that's not.
I mean, on the
I will ask the attorney, but I don't think that's of concern to us. Ultimately, whoever
Yeah, so
the
what
property is getting the
so who I-
citations will be responsible.
Yes, the attorney that I spoke to, Mr. Davis, I explained that the responsibility of the maintenance of the property falls on the property owner.
Correct. Okay, so I definitely, if we can, I want to hear from the attorney for the property owner, which is basically the person that's
Yeah, so
responsible.
my presentation is done. Whoever's gonna be speaking on behalf of the property owner, it will be you.
Speak on the property owner, and then the attorney will speak on the legal.
Well, I'm the attorney, but this is a family property, we're all related, including me as the attorney. And I'm happy to explain the legal side to you, but you might be better off explaining the factual side on your computer.
Okay. Okay, now on the approach, state your name and address, please, for the record.
My name is Margie Smith Faust.
You're gonna have to keep your mask on. I hate to tell you that, because I know it's very comfortable, but for our protection, you have to
Did
keep
you
the
hear
mask
me
on.
okay?
That's okay, get closer to the mic if you want, you can speak louder, but you have to keep the mask on.
Okay. It's funny, I grew up in Miami Springs. I would never do that to my hometown. I worked at the pool for 4 years. I went to school here. My sister Rose and I worked at the rec center. Roro played ball across the street. That breaks my heart. And it's just weird that I met a man back in 1976. He said he grew up in Miami Springs on a dairy ranch house on the International Airport. Turns out the only property that the family had left was this little piece of property that had the ranch house restaurant where we went after every ball game or water polo or swim team. And when he died, the family was good enough to say, since my first husband was the majority interest holder, they said, Margie, you're doing a good job, just continue. So what happened was, I'm sorry, I turned around. What happened was, back in 2014, we had the ADA issue a lawsuit. The gentleman that leases the property, he bought the assigned lease, which my attorney can get into more of that. But I get a letter in 2016, I'm jumping because I know your time. But in July 2016, I get a notice, they're wanting a permit on the fire suppression system. Since the 1970s, this property has been subleased. Or not subleased, I beg your pardon. It was an assignment. And the assignment is purchased just like a piece of property, and it's under a 99-year lease. The tenant is to pay the taxes, pay the insurance, upkeep the property, everything that an owner would do, except, and this I guess is the Attorney General's opinion, the tax notices still come in with the property owner. Margaret V. Faust, who is on this summons or whatever, she is the last transfer from the property appraiser's office. She is also a member of the family. Diane is not involved with any of this.
She is an owner, not a tenant.
She is not, she's an owner, not a tenant. But ever since I got in the family, the only thing we can do on this property is collect the $300 a month and leave the man alone. This gentleman purchased it when Neighbors went bankrupt. Mr. Berlides bought the assignment. He bought 3 Neighbors restaurants, one on Hialeah and
When you say buy an assignment, that's a little bit of, it's not legally correct. They're getting an assignment of the lease, and they can keep assigning that lease for, you know.
Well, he paid money and he got the
When you
assignment.
say buy, it's a whole different story,
Well,
because
he
the owners
bought-
are still the owners.
He bought the Neighbors restaurant on 36th Street, 79th Avenue, flipped that, sold it. The one on 4th Avenue, flipped it, sold it. The only one he didn't own the land was the 36th Street, the Faust property. Now, time goes forward, never had a problem with anybody there. We get this thing about the fire suppression, and I called a very nice lady at the zoning board. I said, we have no control over this. And it was a Seacoast fire suppression system. And I asked the lady in Miami Springs zoning, I said, do you have a city attorney? She said yes. But she checked with her supervisor, and they said, as long as you have a copy of the 99-year lease, give it to the contractor. He got the work done, no problem. But, you know, hindsight's 20/20. I figured out things that had happened. As long as he owned the assignment, he was the tenant. But as long as he had a subtenant in there taking care of everything, everything was done. Well, in 2016, I suppose they couldn't take it anymore. One gentleman has a very nice Greek restaurant on the Circle on Westward, very nice man. Anyway, his brother was the subtenant. Well, he moved. So then Mr. Berlius decides he's gonna assign the lease. So he writes me a letter. I read the lease. I realize, oh my gosh, he's in default. I am 400 miles away.
You just
In
said
Madison,
something, I'm
Florida.
gonna interrupt, you just said something very important.
Yes.
He is in default. So you realize that the owner has a lease with whoever is occupying the property, whether it got signed 50 million times, according to the lease terms, the owner is still the owner.
I understand, and I
I
apologize
just
for the
want you
state
to
of
realize,
this.
and where the
Well,
board is
the
gonna head.
people that were the subtenants, they moved out. Mr. Berlius was there. I'm 400 miles away. I read the lease, I write him a letter saying, we need this, this, and this. What happened with the ADA? They write me back, and anyway, it went on like that. Then, at this point, I had not seen this, and I even brought a jump drive because I wasn't sure whether, I knew you would have the recent ones. But I came down for a deposition in 2017, and I took pictures, and this was disgusting, and there's nothing we can do about it. We've gone to court, the attorney will address that. But anyway, he was issued a permit and got a notice of commencement in August of 2019. He could have started on these repairs, but he didn't. Whenever he needed to do this, he got a variance with the city of Miami Springs for a beer and wine license. We were never asked about that. He used this assignment to get loans from banks. We were never advised because the lease said he could. The only thing we could do is collect $300, split it 7 ways, and leave him alone. That's all we could do legally. This isn't a lease that we could say, get out. He is supposed to maintain the building. He is supposed to pay the rent, have it insured. I've been asking, and we have been asking for insurance. Well, obviously, nobody's gonna insure that. We don't, I'm scared to death. Liability, this is terrible.
You understand that I appreciate
I
everything
know
that you're
this.
saying, but
I
we're
understand.
not gonna issue anything against the tenants. This board is not gonna
I
issue anything
understand,
against it. It's gonna be against the owner,
I totally
just to let you know.
understand. I just want you all to understand that we are doing everything we can do. We've been in court. The attorney will talk more about that, but I would not do this to my hometown. And the people with me in this family, like my attorney says, I'm the youngest and I'm old. But my family grew up here. I worked for the city of Miami Springs. My father was a police officer here for over 25 years. My mother, a school teacher. I would not do this. And I just want you to know we are doing everything we can to end this situation. And I'm telling you, I don't know how somebody can spend money and make it look worse than when it started. And even when Hurricane Irma went through, it took a few of the tiles off the front, but nothing like this. And I didn't get down here, like I said, till July 2017. And when I saw it, I thought, he's not upkeeping the building, which was actually something else when we went to court in 2019. So we're kind of in a limbo right now. So I understand, I do understand that it's on the fee only, but it's one of these situations where our hands are so tied that, and then he says, well, you have to sign the Durham paper. Well, the Durham paper, I can't sign. I will have to guarantee every well field, and I guess he didn't think I could read, every well field in Dade County for 30 years. If I was in control of this property, I would not have any problem, because I know what I'm gonna put in the ground.
That property actually needs to be demolished. It looks like it needs to.
Okay, I agree. if I were in control of it, I'd have no problem, but I cannot sign something, I have no control over what he does. He even had drums of grease.
What's gonna happen is that this board is gonna make a decision, we're gonna have a discussion, we're gonna make a decision, it's gonna affect the property. It'll be a timeline, and then when things are not done, fines are gonna start. So what's gonna happen, you're gonna have fines adding up, regardless of what's going on with the tenant. It's not of concern to this board, what's
Well-
going on with the tenant, because ultimately the property owner is the property owner.
Well,
So we
if-
understand what you're saying, and I
Well, and the
appreciate
attorney
it.
can address the situation with a 99-year lease. It's not exactly, it's a commercial lease. It's not exactly what I know as a landlord tenant. It's more of a contract.
Somebody.
And we are fighting him in court with every breath that we have.
If they're in default of the lease, a court of law has to hear you out and has to make a just decision.
And now I give the podium to.
So I
our
wanna know,
attorney.
is the fence, today, is that fence still down? And as the property owner, somebody should go out there and put that fence up, because if not, we need to contact the county and let them know that it is, and that in your opinion.
Be considered an unsafe structure.
And then you're gonna have real problems, if the county comes in and demolishes it, and then you're gonna have that house, you're not gonna have a building, you're not gonna have, it's just it's gonna be a domino effect.
And I don't have a chain with me. I didn't bring a chain. I didn't know the.
Well, but you're aware of it now. Yeah,
Oh,
but you're
yeah.
aware of it now, so
It's been like that for weeks.
it's been like that for a while.
Well, I just want you all to know that we're trying. The Faust are trying.
We appreciate your information.
Thank you very much.
You're welcome.
My name is Scott Smothers. The attorney that was referenced earlier is Mitchell Davis. He's an associate with my office, just so you know who everybody here is. It's Mary Smothers, that's my mother, Mary Faust Smothers. She's actually the only one still alive that signed the original lease, 1965. Daniel Faust, not on the lease, his father was on the lease. Margie Faust, her deceased husband, Alan Faust, was the 42.5% shareholder of the ownership. That's all that's here. There's 3 other owners, there's actually 6 living owners of this fee simple interest. The original lease signed in 1965 has been sold, as you mentioned, and assigned a couple of times. Mr. Vasilios Berlides is the current tenant. He's held that lease for a very long time, about 30, 35 years. His attorney is Ken Lancaster. Mr. Berlides is local, Mr. Lancaster is local. Margie Faust traveled here from Madison, Florida, and myself and my mother and my uncle traveled here from Apopka, Florida. So we drove a very long ways to a hearing that I guess Mr. Berlides and Mr. Lancaster couldn't be bothered to attend. So as Margie was explaining, the Fausts have been in this awful position for about 55 years where they can actually do nothing with this property. Their job under the lease, and if anybody cares to see it, I'll show you, but their job under the lease is to receive rent and leave the tenant alone. The tenant has the obligation to do everything. Pay rent, pay taxes, insure the building, upkeep the building, pretty much everything. For instance, if there's a lawsuit, like she referenced, there was an ADA lawsuit. They serve the tenant and they also serve the Faust, but the tenant has an obligation to defend. And they did. They defended the lawsuit. They entered into a consent decree with the federal court system saying that they're going to bring the building into compliance with the ADA within a certain amount of time. They did not. They continued to operate the building in a non-compliant condition for about 2 years past the deadline, until finally the subtenant, which was a Greek family that owned the restaurant there, got tired of the tenant, Mr. Berlides, trying to make them pay to bring it into compliance. So they left. After that time, Mr. Berlides never fixed the building, so he couldn't reopen it because it was already in violation of an ADA consent decree. The fines for that are astounding. We're talking $50,000 fines that would come to our family, which of course we would have turned around and given it to the attorney for the tenant and said, look what you did, but it's still going to come to us. And then when you don't obey that first fine fast enough, the second one's another $50,000. So we knew that we were in a bad position, and he knew that he was in a bad position, Mr. Berlides. And so he didn't reopen the building. So that was in 2016. Well, jump ahead just a little bit, and I'm going to jump ahead to something at the end, just so you guys know.
Just at this moment, you haven't taken the tenant to court for breach of the lease.
Absolutely. We sued him in 2017 in front of Judge Arzola here in Miami-Dade County. We had a jury trial That concluded, I have a jury verdict form with me today that I would challenge any of you to tell me what it means. We had a contradictory jury verdict. At the same time, the jury found that the tenant materially breached the contract in 6 ways, while at the same time finding that the house were not damaged. So what does that mean? He breached the lease, but we have no damage. At the same time, the jury found that the house breached the lease, but that the tenant had no damage. So we all sat there when the jury was excused late at night in the Miami-Dade courthouse and looked at the judge, who looked at us lawyers and said, I told you were going to get a contradictory jury verdict. This was too complex of a contract case to bring to a jury. You guys should have known better. Okay. So we all left. There's one cause of action that's still before the court, and that's for eviction. The counts that we went to jury trial on was for breach of contract and other similar damage action.
We're trying to recover money and that failed. So ultimately, the owner can evict the tenant that's not in compliance with the lease.
Well, ultimately, if the judge will allow us to, because that was a cause of action we brought in the 2017 case. After that jury verdict, which was in February of 2019, I've been back to court numerous times, asking the court, I filed motions, judge, give me summary judgment on the eviction issue. Judge, give me a new bench trial just on the eviction cause of action. Just do something. I can't get.
Have you hired local counsel? With all due respect, I'm an attorney myself. Apopka is very different from Miami-Dade County.
I understand. I've had cases and jury trials in Broward and Palm Beach counties. My family's owned this property for 115 years or so, and I have no problem with Judge Arzola. He's actually a very good judge. We had a jury that absolutely did not understand what they needed to do, and we got a very weird jury verdict from them. Judge Arzola, in my opinion, doesn't really want to rule because it's going to be very harsh to one side. Either he's going to kick out this tenant that's got 44 years left on his lease, or he's going to refuse the eviction.
Owner is responsible.
Right.
Bottom line.
No, I understand.
I can tell you that that's where this board is gonna head when we have our discussion. So it'll be just, it'll be one more, if we do, suggest a daily fine, and give them, take photos of the property.
It is all public record.
I mean, this is all public record.
Today, any
Right,
photo that
amount or flat amount or whatever it is that we're gonna recommend, it's just gonna be one more item that the owner's gonna be responsible for.
I understand. Thank you.
At some point, there's gonna be so many fines and so many things going on that the property is really almost even, I don't know how far you keep going to, I don't know. I don't know what to say.
Well,
Anything else on the owner's behalf that you would like to say?
yes. One point that Ms. Faust was trying to make was that anytime that anything's ever had to be done to this building, the tenant's been able to do it without us. We've never been asked, we've never signed, when I say we, the Faust family has never signed a single permit application, ADA compliance, consent decree, not a single thing in 55 years have the Faust had to sign or do for the maintenance or upkeep of this property. This is the first time, and I know what I was saying earlier. I found out about this on Thursday. Why? Because these notices don't come to us, even though they're supposed to go to the Faust. They actually go to Mr. Verlies' other property here in Miami. He owns a strip plaza somewhere else in Miami, and that's the address that's actually on the summons here. And Mr. Lancaster, who I have no personal problem with, he's been Mr. Verlies' attorney for a long time, about 30 years, was kind enough on Thursday afternoon to say, hey, you might want to know about this.
Maybe you need to go and see and visit the Dade County Property Appraiser's office and let them know who the owners are and bring proof and have addresses changed and keep them up to date.
Yes, when I spoke to Mr. Davis, I explained that we mailed everything to the address on file to the property appraiser.
Which is what
We didn't change. Yeah, we didn't change it. The tenant changes it to himself so he can get the notices for the taxes because it's his obligation to pay the taxes. So he doesn't want the taxes coming to us. He changes it back whenever we change it. So we've made all these, I can tell you a dozen ways that this tenant has breached this lease. And this is a very good lease. It was written by very smart people back in the sixties. Now, the problem with the lease is it didn't have a rent escalation provision attached to anything like inflation or consumer price index or anything like that.
Right,
So it had
or an ADA provision, or.
Well, it actually-
Pandemic provision, or.
It actually had a provision that said that the tenant has to keep the property in compliance with whatever the local, state, or federal laws were at the time. So it did have a provision that made him have to comply with the ADA, but didn't have any provision for rent escalation other than, it says something like after 50 years, it goes up $50, or 25 years, it goes up $50 a month. And after another 25 years, it goes up another $50 a month.
Right, but that has nothing
So,
to do with the matter.
I
at hand.
understand.
That has nothing to do
So
with the matter
the
at hand.
Faust have done nothing for 55 years but do what they had to do. And they consulted attorneys long before I was born to say, are we really gonna have to sit here for 85 more years and just take $300 a month from this property? And the answer was yes. Many attorneys have been consulted over the decades to find a loophole to this lease. The closest thing we ever found was when he didn't comply with the ADA consent decree, we came down here and said, well, hold on a second. That ADA consent decree said you had to fix the building and bring it into compliance with the ADA by a date certain. And we're discovering right now that you operated that building for 2 years past that consent decree date. What's going on? That's a breach of the lease. You put us at risk of a $50,000 fine by doing that. What are you doing? Oh, well, there's nobody there now. It's not open. We're not technically violating the ADA. Well, that's not what our lease says. Our lease says you have to have the building in compliance. I don't care if you're having it open or operating it. That's not our problem. The building has to be in compliance. But again, we sued him in 2017 foreseeing this, because when we saw the building in 2017, we said, it's not looking very good. I don't think you're maintaining it. Now, it didn't look like it does now. We were just there today. I agree, it's in a deplorable condition. But even in 2017, when we filed the lawsuit, we said, you're in violation of the lease for not maintaining the premises. This doesn't look good. Problem. So we sued him. We had the jury trial in early 2019, and we got the contradictory jury verdict. I've been back to court a couple times, and Judge Arzullo really doesn't want to do what eventually he's gonna have to do, which is either evict that tenant, and he's gonna lose a 45-year property interest right, the leasehold interest, or tell us, no, I don't think that there's an evictable offense here, and you know what that swing is gonna be? About a $200,000 attorney fee claim coming from my opposing counsel for doing multiple years of litigation. He also associated as counsel Patrick O'Connor, who's a very good litigator in downtown Miami. Again, much respect between attorneys. We have no problem with each other. Mr. Berlides is an elderly gentleman that's very stubborn. My family is getting up there in age as well. Everyone's a little bit dug in, but the property continues to go down in condition, and we're kind of stuck. Like, we would love to come in. I mean, we've had a year and a half of settlement discussions saying, we'll buy you out, or buy us out. Obviously, we can't coexist in this property, but either let us buy you out so we can knock it down and build whatever we want to build, or buy us out and you do whatever you want to do. But we have a problem where we can't get to that point with Mr. Berlides. So, if you remember, and I know that your time is valuable, I don't want to keep going on. It's an interesting story, but it's a very long one. What we've gone to today with the jury verdict was the jury found the Faust had no damage. And as an attorney, you realize what you guys are going to do is create damage for me. So as soon as you let me a fine against this property, I'll be back in front of Judge Arzullo as fast as he'll let me back in this courtroom or on Zoom. And I'll say, Your Honor, I have damage. As you know, the jury ruled we had no damage. Here's your damage. You have to grant me a hearing. You didn't give me a hearing on summary judgment. You have to give me a hearing on summary judgment. Facts have evolved since the jury verdict, because his concern was, and again, you'll appreciate, his concern was he didn't want to issue a ruling that contradicted the jury findings. So the jury found 6 instances of material breach, but at the same time found no damage. So I've had to craft arguments that were essentially, okay, well, that was the state of the facts in February 2019. Look what's happened since then. You have to take these new facts into consideration. And if you issue a finding of a fine, that's an additional consideration that I'll have to argue that Judge Arzullo should be considered. So I'm not asking you to fine us, by all means. But at the same time, I'm going to be in court as fast as I can to say, we've done everything we can. We've complained and complained and complained to Ken Lancaster, to Patrick O'Connor, and to Vasilios Berlides to say, take care of the building. cannot leave it like this. And what does it look like? We were just there.
And I drive by there, we all live here.
Yeah, Judge Arzola
I don't know if
drives
you
by.
understand that, I drive by there daily.
Yeah, Judge Arzola told us that he
Twice.
drives by it all the time. He knows exactly the condition of the property.
Securing the property with a fence, can the property owners have that fence? Whose fence is that that's there?
The tenant put that up.
So the tenant applied for, I mean, I don't know who applied for the permit.
The tenant applied. We've never applied.
Somebody applied for the permit,
Okay,
and they were granted a temporary fence for construction.
okay. I just have a problem, definitely, we need to contact the county and let them know that the fence is down. And it has
Well,
to
we've
be down.
already contacted the county because of the state of the building, so we wanted to, even if it could, go straight to the unsafe structures board for the
Correct.
county.
Correct,
But the county says that ultimately, all they're gonna ask for them to do is board up the building and put a boundary around it.
okay.
So that's,
Well, keep bothering the county, the fence has been compromised, we cannot have, people going into that property and putting us as residents at risk, and people, tourists that walk on the sidewalk, it's just not, that's not right. That's not right, so
the
please.
neighboring buildings are behind our multifamily
Correct,
that, have been impacted by it because they don't rent there, they purchase these apartment units. And they said, throughout the years, the quality of their life has decreased as they've seen this building just, get worse and worse and attract the things that's attractive.
Yeah.
It's not good.
No, it's the floor. We
people
agree.
doing drug use and everything else that's going on there.
And
We don't need that in our neighborhoods. We pay a lot of taxes and upkeep of our homes, we do not need this, absolutely not.
Right.
Okay,
So-
is that all you had to say, because we need to have a discussion?
Sure, and just, if there's any questions, and
This
if.
gentleman over here. Yes, sir.
Happy to answer them.
You may come up. State your name, please, and your address.
I also was born here in Miami Springs.
Start with your name, you start with your,
I'm sorry,
start with your name and your address.
Daniel Faust.
With your address.
My address is 40442 County Road 452, Leesburg, Florida, 34788. Okay, I was born here in Miami Springs. And anyhow, the only comment that I wanted to make is it's my understanding that we, the Faust family, doesn't even have the legal right to enter the property and touch anything or do anything. If we wanted to rebuild a building, we don't have the legal right to do it. That's my understanding. So that's all I wanted to add. Under the terms of this lease, we can do absolutely nothing to the property as the family.
Thank you, thank you, sir.
Anybody else have any comments?
I don't have any comment, I'm available for questions, I know it's a tough situation, I appreciate you guys.
So you currently still have one item pending in court? The
There's one
eviction.
cause of action.
One cause of, one
Right,
count.
there was a case brought, and there was a counterclaim, and every cause of action could be considered by the jury except for eviction, because that's a court sitting in chancery,
Okay.
and they're not allowed to consider that by the jury. So that was not taken to the jury. After that time, the court won't rule or give me a hearing. Now, I'm sure he will eventually, but
Because of the COVID situation, or,
no, it had nothing to do with COVID. The jury trial was in February of 19,
okay,
so that was quite a while ago.
1990?
2019.
19.
Yeah, 2019.
Okay.
So what the court's initial problem was he didn't want to issue a ruling that contradicted in any way the jury verdict. And so he says, brief me on how I can rule for you and not contradict the jury verdict. So we both submitted memos arguing our sides of, at that point, the other side had no cause of action for affirmative relief left. All they had was to defend the eviction count. And we were arguing to the court that, look, they found 6 material breaches of the lease. While there may not have been any financial or monetary damage, at the same time, just the breach of the lease is enough damage to give us a possession.
So has he ruled, is a ruling pending on that?
No.
And has anybody, done a motion to
I
get a
thought-
status update, you know, you gotta,
I filed a motion for summary judgment. We had it set for hearing, and then COVID happened, and all hearings were canceled. For a while there, judges
Right,
wouldn't even
I assume.
give us hearings. Now the courts have decided it's not a vacation, and they're gonna start giving us Zoom hearings. So we're doing Zoom hearings, I'm doing Zoom hearings almost every day, all over the state. So I do them from my office, not a problem.
Perfect, thank you.
I think the damages are definitely gonna help them.
And now we go to the rest of the story.
Yeah. Huh.
I pass it every day.
Yeah, me too.
I've breakfast there many a time.
Yeah.
Okay.
Wow. This is a big one.
It is a tough one. I know that my fellow board members know right where I'm headed. This just cannot stay that way. Someone is going to, the owners are ultimately responsible if you do not have a correct address at the property appraiser's office or correct owners, whatever is going on, council, I suggest you visit the Dade County Property Appraiser's Office. Correct whatever you have to correct. The owners are the owners, period. Period. Maybe they can do a notation in their file. That's like you telling me that one of the code enforcement board officers is gonna go change the address on my property so that they can get the mail. Absolutely not. Please address that. Notices will continue to go to the address listed at the property's appraiser's office, and the property owner is gonna be responsible. You're on notice that there's something wrong with the address. Please correct it.
Well, the fence has to be taken care of right away because you have so many people in that area from those motels and everything else that's around that area. It's very negative.
But it still falls under the same code, the maintenance department. It's called, the code, and our code says that it can't, create an unsafe area for the community. So that's just still under the same violation, 9330.
If you have to contact the county on a weekly basis to have action on their part, whatever action is gonna be had on their part.
So previously, when the fence was broken, that it was, sections were down, the tenant put it back up. So I just found out on Friday that the fence was down, because the last time I was there, the area was secured properly. So I will be notifying.
Even with that fence, if a hurricane comes, all of that debris could end up in my house. That debris could end up in my house. I mean, very unsafe.
Okay, so what we're gonna do,
We have to make a motion for,
I'm gonna suggest some type of daily fine. We can do a daily fine, it's gonna be big, it's gonna get some attention. This property cannot continue on.
we're gonna give them any time.
I will be happy to give them time. We can give them time, maybe they can present our order to the court.
Right.
Where he has his pending matter, or he can file another lawsuit, or whatever it is you need to do. That's between the family and the attorney. We can give them a little bit of time, and then a fine is gonna start automatically. What that amount is, we can have a discussion about that.
Okay, what period of time do you feel that we should give them, George?
I've got a question. What does it take for the county to come and
Demolish it.
So we looked into it, they wouldn't demolish it.
They just demolished the 70-year-old man's home because it was an unsafe structure.
So that's, the only thing the county comes, the only area or the stage that the county comes in is to utilize their unsafe structure rule. So building official would petition, declare it to be an unsafe structure, and we would apply for an unsafe structure here before their board. And we would declare it to be an unsafe structure, and we would present findings of fact, conclusions of law. It would be quasi judicial, just like this, except it would be before, an unsafe structure board. And they would, if they agree with us, they would render us an order. Essentially, usually it's giving the property owner time to demolish, because it's always cheaper when the property owner demolishes. But failure for them to do, so authorizes us to enforce the order. And we go in there and demolish and levy a special assessment lien for the amount of costs. So we would do the work. We'd get the authority from the county.
And include the fines, so we would have to pay for the demolition.
Yeah, we would, and the costs. We
We
would pay for it.
we put a lien against the property for that cost.
Yeah, at the conclusion, and when I mean everything is done and said and done, we would, assess the property, the amount of our costs. We're enforcing the building code and seeking compliance, and getting compliance. So that's how it works out.
So basically, we'll be giving them time, we can give the owner some time, they're gonna see, I would suggest some type of timeline. I would hate for that building to, I know nothing is gonna get done right away, I don't wanna give too much time, maybe a max of 90 days. Have council present our order, we're gonna have a daily fine after that 90-day period, it's gonna be a substantial daily fine. And, you know, you'll have that order to present to the court, and, you know, maybe it will help you, maybe it won't, I don't know. I think that would be my suggestion. I don't know what the other board members, and definitely the other route with the county, if we could keep an eye on that and definitely
Yeah, and
pursue that.
And it would also cost money for us to go in front of the board.
Correct, and I understand
So
that.
we wait out before I even brought it to this board,
Yeah.
we wait out to even go there first.
That probably, I think that's, given the condition that it's in and the circumstances of what's going on, and I know it'll probably create other legal issues down the line, but, we can't have that. We can't. I cannot say that.
Could we, set 90 days, then we levy a fine, per diem, right? And then after, if it's uncompliant after a year, could we pursue that
The
other?
permits are approved, pending county approval, so it's not like they need a lot of time for the permits, for the remodeling and the, you know, to be approved and to be issued.
Well, you're saying for the tenant to come up and do that. Okay, so
So
that's not gonna be of our concern,
Yeah.
because right now, we need the owner is gonna have to come in compliance. However it is that they're gonna get permission from the court, we're asking for the owner to come into compliance. We're not gonna be directing the tenant.
No, we're not directing the tenant, but
Correct.
there is a legal permit that was applied to remedy this
That's fine.
issue.
That's fine,
That's been approved that's been approved, reviewed and approved by our city.
that's fine, and I would
what are
suggest,
the renovations? What are they?
The ADA compliance, bring it all to ADA compliance, and then renovate the interior and exterior.
and the roof, everything has to be
Everything.
done. That has to be brought down to a shell.
That's-
That building has to be brought down to a shell, we don't even know if
So
the
they
shell
put
is.
Princess for a new structure for the roof and everything?
I don't know the specifics, I haven't looked at the plans.
It has to
But
be a new
They
roof.
destroyed what was there.
I mean,
There's no roof
I
there.
haven't looked.
I mean, structurally, what's there is destroyed, whatever they were
They
doing.
submitted a set of plans to renovate the interior, exterior, and bring it up to ADA compliance. That's what the note says.
Okay.
And that was, issued.
So it hasn't been issued, but it was approved, I want to say sometime late last year.
Okay, so there's been no action on that since late of last year.
Well, this is just, the issue was not taken care of, and the permit hasn't been issued, and it's been going on for so long that it was due already for the code compliance board. But we've had, like I said at the beginning, on and off issues that have been corrected, and, you know, the state has never been like this in the past. This is just the worst it's ever gotten without anybody doing anything.
All right, so we have to be careful how we tie in our timeline and what we're tying in our timeline to.
So you're going in based on this case, It was opened, earlier this year.
Earlier this year. And then COVID hit. And now it's happening.
And your
But this is a this
citation,
is a repeat offender of this,
Yes,
of this
right.
violation.
your uniform civil violation citation, what is the specific,
It should be on the, I don't remember off the top of my head, but,
It's the lawn maintenance.
maintenance of property?
the ticket should state what the,
We don't have a copy of that, we streamlined
The
our.
ticket should be
Property is incomplete repair.
77?
Complete repair and neglect.
It's number 70,
And it's
case number
the
77.
complete violation of any section of code 9313, which is maintenance of property.
Of ordinance 9319.
9313.
Okay, so can I get a discussion so far as a daily fine amount after a 90-day period, let's say?
And the only reason I said that about the permit is that maybe we don't need 90 days,
Yeah,
maybe we need less
90
time.
days is too much.
Last time, you said it got approved already.
Yeah, because the plans are approved by the city pending approval from the county,
Okay,
so,
Let's do 60.
I mean, I think 90 days is overkill for, if the tenant would wanna solve the issue, you know what I mean?
okay, so we can reduce it then to 60 days? I don't know what,
Is,
yes,
is the board gonna impose a fine?
yes,
Okay, this
Yes,
time,
yes.
and then all you have to do next time is just say certified.
correct. My suggestion is to the board, and we're gonna be discussing it. I suggest we'll give them a 60-day period to come into compliance with ordinance 93-3, property maintenance, of the entire property maintenance to come up to code, 93-13. And then a daily fine after 60 days if they have not come into compliance per the 93-13 ordinance. That's a city ordinance, correct?
The municipal code.
Yeah.
Municipal code,
Okay,
okay.
so you're saying you're gonna give them 60 days to bring the building into compliance?
Yes, I am.
Well, it's not gonna happen.
That's fine, that's why
I
after
mean,
60
it's
days,
physically not, well, I'm just saying, if they
For
start
60
tomorrow
days,
with
maybe for the permit to be issued.
Listen.
Yes.
For 1 minute.
Yes.
They apply for a permit, the permit's ready.
correct,
They haven't settled with the county, whatever it's Durham, whatever it is.
correct,
Okay, so let's say they get it tomorrow.
correct.
Ain't gonna be done in 60 days.
I don't think it's.
Yeah,
gonna
they'll
be
have
done.
And here they got a permit, an active permit, everything ready, and you're still only gonna give 60 days. I'm not arguing with you, I'm just telling you that ain't gonna fly.
It's not, they're not, even if I give them a year, they're not gonna do it.
So sure, they do the building in a year, they do the building in 6 months, but not 60 days.
So maybe,
Not that building.
Okay, all right. So you're saying give
Well, I
them,
mean, we're gonna make a ruling on something that's impossible. It's hard to
that's why I wanna hear numbers.
And they already got a permit, meaning it's ready to go, except they haven't been to the county to pay whatever the impact, or whatever.
And they need to make an effort too. Somebody needs to make an effort to take it to the county.
These people can't make an effort.
I understand that. But I
Okay,
cannot,
well, I'm just saying, we're gonna make a ruling that's impossible.
yeah, so
we
maybe it's
cannot,
for them to
this
receive an
board,
issue permit, because once they have an issue permit, they have 6 months.
this board cannot rule and force a tenant to do something. The only thing we can do is look at the owner, and ultimately the owner's responsible. Any fine that we put, any timelines that we put, any orders that we put in is against the owner. And I understand your.
Okay, well, I'm just saying,
Yeah, so-
physically impossible.
I would remove the permit out of the
Right,
equation,
I'm not gonna include the permit.
because the issue here is the maintenance of the property. They can fix the property by demolishing the property,
Exactly.
or they can
That's
fix
what
it
the
by
rest is.
mowing the lawn and boarding the wall, the windows. They can fix it in other ways, they don't have to fix it by renovating, right? So I would remove I only mentioned it,
I'm not going to
permit
connect
is
the
fine.
permit at all, that's why my statement is specifically with ordinance 93-13. That's why I asked for the specific ordinance on
it would
it.
be 60 days for them to come into compliance with 9313.
Correct, period.
Of maintenance,
Maintenance of property, and then we need to discuss a daily fine amount.
I think.
And in addition, just so that the owners are aware, and Robert, you can correct me if I'm incorrect, this violation citation 00473 of $100 needs to be paid.
Yes.
It needs property owner, it needs to be paid. So this is separate and apart from what we are going to, the order that we are going to pass today. This civil violation notice citation needs to be paid.
Let's just, like,
And notice has been issued to the owner, so this is an owner responsibility.
That's correct.
okay, so the fine,
Fine amounts, George, suggestion, a daily amount. Just so that you know, in other, I know you, in other, I'm up there to 4 digits.
But I'm trying to wrap my head around this, because they can't do nothing. The tenant apparently is not gonna do anything, because he's had that permit, whatever issue, I don't know how long ago. So I'm having a hard time issuing basically an ultimatum, and neither party can do anything.
Does it solve the situation to do nothing?
Well,
Or have something in place, and then, if they resolve the issue, they can come back and we can have a discussion and see what has transpired.
but George, our decision here today will help them to go in front of the judge and get the judge to rule, to basically help them with their case.
And aside from that, the board knows me very well. Everything that I've mentioned and the way that I'm formatting it is what I normally do in the cases. Aside from, you're gonna have something to go to court, say, here, this is what's going on.
Yeah.
I have this timeline, now we're getting fined on a daily basis against the property itself. The day you go sell that, it's gonna be on there. Adding up on a daily basis. Our discussion is closed, right now for any comments from you. This is our first time in this setting, so we apologize if we can't hear, or sometimes we can't even see with the lights on, so our apologies for that.
Yeah, this is not the norm.
A little bit of a different setup for us, we usually in City Hall, so. So far as the daily fine amount.
I'm sorry? Oh, so just for the board's reference, first time offense per diem, if you're gonna impose a per day fine, it's up to $250 per day, so you can go as high as $250.
I'm sorry,
That was my figure, 250.
The maximum amount for a daily fine for first time offense is $250.
And is that in an ordinance?
That's by statute and by ordinance.
250.
They would have been in the board for, this would have been the second time? It could have been 500.
I've done $1,000 a day,
You've each got.
which is what I would want today. If I could, I
All
would
right,
$1,000 a day.
let's make the ruling
Yeah.
or
Make the motion.
I'm gonna make the motion, and I wanna word it specifically. I'm gonna give the property owner 60 days to come into compliance with ordinance 93-13, property maintenance. Following that 60-day expiration, a daily fine of $250 per day until the property comes into compliance with 93-13, property maintenance.
Okay, do I have a second?
I'll second it.
Okay, Madam Clerk, Board Member Figueira,
Aye.
Board Member Corey,
Aye.
Board Member Martinez Regueira. Aye. Board Member Bangston,
no.
Board Member Diaz,
Aye.
Chair Jimenez.
Aye.
Okay, passes 5.
Okay. So you'll receive this in writing, the order, you'll receive it in writing.
Can I give you my address?
So I am supposed to send any documentation to the address listed on the property appraisal. But this is public record request.
You have a card?
I do.
Can I have it?
It's likely.
Yeah.
Please be sure to visit the property appraiser's office.
Thank you. You're welcome.
You,
Thank you.
you can request a public record, anything, so request it, to me, and I'll email it to you,
Make sure you go to the property appraiser's office.
I know we've done it before, accused of that.
And then you keep doing it. Or let the property appraiser's office. We can't, some people can't even go apply for homestead exemption, for heaven's sake. And they're the legal property owners. They give them a hard time. I don't understand that. I don't understand that change of address. Don't understand it. I thank you all for making the trip down. You're done.
Yes.
Have a good night. Thank you.
Thank you. Bye-bye.
Thank you. Good night. Good night. Notice the next case. Well, we only have one party present.
Number five is, I'm sorry.
This is, page 84 in the packet.
Eight-four?
Yes, 84 in the packet.
Give us a second. And it's case number
It's case
five?
number 20, yes, case number 5 and case number 2803.
Case number six. Case number, where are you getting case number six? I only have up to case number 5.
Case number,
She probably has the old agenda.
Oh,
I-
okay.
I left you a new agenda.
Case number 5, 20083?
yes.
Okay.
So this is case number 2803, property address 359 DeSoto Drive, code violation 15104, application for building permits. On February 5th, 2020, during a routine daily inspection of the city alleyway, they observed someone working in the rear of the property. Moreover, I heard construction noise. I called the building department, and they stated that no permit was issued for construction. I knocked on the front door, and the man inside refused to open the door. From the front porch, through the window, I observed the following work without permits. Complete replacement installation of new floors, new kitchen, including plumbing and electrical, new breaker box, new rear door, and inspection is required for the bathrooms, which I assume that they might have been, but I can't confirm that they have been remodeled, and a new pavement or removal of pavers in the rear. On February 17th, due to no contact and continued work, I issued a red tag on site. On March 4th, 2020, I issued a final civil infraction notice. On March 13th, during routine inspections, I observed that the front door had now been replaced without a permit. On June 14th, I issued a uniform civil violation notice, number 465, in the amount of $100. I sent it via regular and certified mail. On June 26th, during routine inspections, I observed that the front porch was remodeled, steps added, existing columns removed and replaced, and a new concrete walkway was built. On June 30th, uniform violation notice 465 was paid. On August 21st, I prepared the summons to appear in front of today's board. I sent it via regular and certified mail and police. On that very same day, Officer Llorenz, badge number MS0186, served the summons to appear to Luke Thomas. So this is the property photo that we had when Rosemary did the reoccupancy inspection for the sale of the property back in October of 2019. And I put this because of the pavers that I was talking about. Here they are all lined up. I couldn't take a closer look at this from the alleyway. This is the front door. You can tell there that the floors were replaced and the whole front porch was covered in debris. You can tell that debris was being moved in and out. That's the vehicle of the gentleman that was working inside the property on February 5th. This is on February 17th, when I posted the red tag, stating interior work without permits, exterior pavers or concrete and rear, no permits, kitchen, bath renovations, floors, electrical plumbing. Then, on the 13th of March, I noticed that the front door had been replaced, and that my red tag had been removed and no contact had been made. This is the property before, on October 29th, when it was, the reoccupancy inspection was held, and this is the property now, on June 26th. This is the walkway, that was the concrete walkway, and as you can tell, the extension of the steps in the front, removal of one, or maybe all columns. I don't know if they were replaced with other columns, or if they were like resurfaced in some way. And then the stone, stucco or plaster that was placed. And then the property owner is here with the permit runner or permit process.
All right, so if the gentleman is gonna say anything on the record, he was not sworn in. So just letting you know that if you are gonna testify or say anything, I don't recall seeing you stand up when the oath was being said.
That is correct. I did not stand up because she's going to speak for me. In the event that I have to speak, I'll be happy to swear.
Thank you, sir.
You may,
Can you please approach the bench and state your name and your address, please?
Hi, my name is Kindra Lopez, South Florida Farmers and Consulting LLC. And my address is 4139 Southwest 194 Terrace, Miramar, Florida 33029.
You said WIRMS?
No,
No.
YINDRA.
So who is Worms LLC and who is here on behalf?
He's the owner of the company, he's
You are the
owner.
manager of the company? And you're not gonna speak? You're the owner? So you are the permit runner?
Yes,
So you are the property, you are what, the manager of the LLC? I need for him to be sworn in, if not, I'm not, you know, I can't even ask him a question.
No, the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Okay, so let me understand, you're the manager of the owner entity, and you're
the
not
permitting company.
and you're the permanent, okay.
Okay, he applied really for a permit last year. He was not familiar too much with the process, so they asking like so many back and forth, so in the end, he ended up to give it up, like, not to finish all the permit application with all like the set of plans. Our company is helping him to get the full set of plans. We have a company with called Kalk Engineering. They already have almost all the set finished to take it to the city, so we can just complete the permit application and get all the inspection done and bring the property into compliance. For the stuff outside the house, he was not familiar that he need to get a permit because he was thinking that was more like a cosmetic stuff. We just asking at least 60 days to complete the permit with all the plans. I don't know if it maybe have to go to the county or not, and Durham is like taking like a 1 week, almost like 2 weeks to process all the permit, just in case the city send us to Durham, Miami-Dade County. But he already, the problem he had, the engineering company charged $5,500 for the set of plans. And the work, it was like very slow for him, so he just completely, like, the last payment to the engineering company. Okay?
What permits are, what stage or the permit has not been?
No, there have, for all the things that I described, no permits have been submitted.
Okay.
It was only like, he started the process last year, but he ended up nowhere because, you know, when you do as an owner and you don't do like the full set of plans, like properly done, it's like you don't going anywhere. But the work was like really slow for him and his wife. This is their premier house, and they are like new owners. So he did the stuff incorrectly, but we are gonna comply with everything the city say to bring the property into compliance.
Okay, so, you have anything else to add? I know you wanted her to speak, but I have questions for you. Okay. So this is your homestead? This is where you're gonna
It
reside?
will be my homestead as of next year.
Okay, and, please state your name and your address, because I know the chair.
My name is Luke Thomas in Morisano. My address is 359 DeSoto Drive, Miami Springs, Florida, 33166.
Okay, so you are a Miami Springs resident. you understand how strict Miami Springs is with doing work without a permit.
I have become familiar
How long have you lived in Miami Springs?
since February.
You bought your home where you're living in right now since February of this year is when you've moved to
I
Miami Springs?
purchased the home in the name of my company in October of 2019.
Not Miami, correct. And I saw the deed, that's what I was looking up, and I was trying to look up your company to see who else was.
I did not begin to reside into the structure until February of 2020.
How long have you lived in Miami Springs? Forget about that home. Forget about the house at hand. How long have you lived in Miami Springs? Have you lived in Miami Springs before?
Never.
Never, okay. All right. So how much time do you think you need to complete the permit application for it to go through the process? Give me what your thoughts are. I heard from the permit runner, and I think the board would like to hear what your thoughts are.
In my world, the reasonable time would be 90 days, and that's because I'm not sure of the added expense of what is needed to complete. And since I'm in the process of refinancing the home into my personal name, that will give me the cash leverage to do whatever I need to do it right.
He's gonna put the home in his name now, that it's under a company name.
If I might add, the reason why it took so long is that it has to be owned in excess of 6 months before I could put it in my own name. Once it was in the corporate name, I should have bought it in my own name to begin with.
Well, that's not any of our concern. But I'm specifically asking you about the time that you need for the permit, and you said 90 days.
I do.
Now, but it's, John, I don't know about the timelines again. I know that you're more familiar with timelines when it comes to approvals and things like that.
Do you have all the paperwork ready?
We do.
Yeah, we just did the last payment, last week to the engineer because they have like different payments. And they just finished all the electrical and plumbing. The structural stuff is already done. They just finished like the plumbing and the electrical, that's it.
Okay, so you got all the engineering, all the electrical engineering, all the structural engineering,
The structural building is ready, yes.
90 days.
The building permit, it is a little bit delayed now.
And I was gonna ask you, what is your
Due
timeline?
to COVID, we've had our bit of our setbacks. So,
COVID and not being in your own building.
yes,
Correct.
it's a double whammy for us.
Where are you guys? You guys are here or you're in the
We're-
trailer?
We're up there.
Oh, you're up there, hi. Hello there. Okay. All right.
So you think 90 days is sufficient time for them?
If they're requesting the 90 days, I would say then yes. If they're really are ready to submit the
Well,
paperwork.
he's close, he's got engineering in there.
Are you sure you're gonna be ready? Because.
The problem is, I don't know what the county, because let me explain to you what happened, that we've been having problems. The county right now, you have to get an appointment for them to put the stamp. A lot of these cities like Pine Crest and I don't know, Miami Springs, they require you have your plan with the Durham stamp.
Based on the work that they've completed, it's under my assumption that they will not be going to Durham. Durham is when they perform 3,000 total square feet of work, maybe like an addition or something like that.
Okay.
All their work is interior and some minor exterior things. They didn't add an addition or anything like that that would create an impact to the community, so I don't think the plans will be assigned to Durham.
Right, and that's just your opinion, that's not, we don't know that for sure.
The engineers say they could be sometime, and that depends on the reviewer, because he said if he look on the demo, it's more than 140 square footage in any kind of wall in the interior, it would be required to go to them. So, I
No,
don't know.
we really don't, well, we don't have the exact answer either, so.
What did you say, Alfred?
No, you said that they're modifying the kitchens and perhaps the bathrooms, you said, right? So,
So from what I can tell, they're all level 1 alterations, remove and replace, except the kitchen, it seems like it was modified a bit more, but it's still within the same vicinity.
Yeah.
So it's not a level 2 alteration where they're reconstructing walls in the interior, it's pretty much remove and replace. So
should make a motion then to give them a certain amount of time.
Well, if he's requested 90 days, I'd say
And
90
do
days.
you wanna also add a fine if things are not done after the 90 period, but we're gonna, that way you have a time period, and then you have a fine that's starting. It puts a little bit of fire under you to make sure. I know you hired somebody, but ultimately, just like you heard me say on the previous matters, the owner is responsible. So if your runner company or anybody that you're hired is not working out for you, then you need to find other people to help you get things completed. So that's happened as well. Yes, I think fine is.
Just to be on the safe side, if you guys could do maybe 4 months instead of 3, I think it would just be.
Can't they ask? This goes back to the other case, can't they come back and ask one time?
Well,
You say when we make an order, they can't come back.
well, we can't, so let's say they're 10 days prior to the end of the deadline. And
No,
they
it
ask
comes
for,
before the deadline,
huh?
before the deadline. I'm not saying after.
No, I mean, whatever time before the deadline, they can ask for the extension. And once you're heard, I mean, typically, if they don't meet the deadline, we'll do the order recorded at the county and the deed is processed. So that would require me not to do my job, not put the lead through and wait for a possible extension of your part. Because you did give an order, it's not like you granted 90 days with no penalty.
So when we grant people more time, we haven't made an order yet.
Granting of time, but granting of
So
time
when
with a,
they do an order,
with a
90
daily
days
fine,
or a
it's
daily
different.
fine commenced,
That's different.
and it's voted on, it's an order. And that can be recorded at the county and lien on the property.
And it should be recorded immediately.
Yes.
So, okay, so if they give an order, just like with any case, you get into a grace period. With, like with the last case, you gave a grace period and you included a fine. If at the end of that grace period, they haven't come into compliance, then I believe they could be, brought
So
back,
they can
right?
give a grace period now with no penalty,
Right.
and then they can come back, and then they can start to find maybe.
The only thing that,
Or you know, or-
that process of not, putting a fine right now makes them come back, makes them come the case before us again. The reason why we've started instituting fines, a time period, a reasonable amount of time, and then a fine was to avoid them from having to
Yes,
come out.
like you said, at the moment that you do an order, I record it within the next 2 weeks, and it's recorded at the county. When they do an order, they vote on it.
And including a grace period?
Yeah, there's some motions like that they've, given a certain amount of time and then a fine begins, and it gets recorded that way.
But when it doesn't have a fine, I don't think they said anything.
I thought it was taken back for certification, just to solidify or validate that the fine, that the violation still exists, and then they say, yeah, we and I recorded. No, it's just that,
Well, from our previous conversation, it was record if there's an order. If there's no
if there's,
order, then we don't record anything at all.
right, you can't, you're right, there's nothing to do.
So basically, the work is done, correct?
I haven't been inside, I could only see what,
The work is done, okay, and it's
finished.
hopefully done up to code. They're very close to their paperwork. The only iffy thing is germ possibility. So, John, you mentioned how many days? 90 days?
He says 90 days, but if we can't, the other guy said 60.
Right.
And we're gonna come back for a fine reduction because, I don't want them to come back for a fine reduction.
No, I
At
don't,
the same time, I don't wanna push it any longer than it's possible needed.
correct, I understand.
That's
But it's,
basically what I'm saying.
you
I'm
guys-
not saying that
You guys are
to
saying 90
hurt
days
or
to get a
help. I'm
permit?
just saying that they should have it that time with no problem.
90 days to get a permit.
To get the permit, not to finish all the inspection, no? Just permit.
No, just to get the permit.
I think
Okay.
it's enough time.
I think 60 days would be enough.
60 days.
Well, you
better
have
off.
the paperwork, 90 days, 90.
90 days.
You said
90 days, not
Fine.
60.
I'm talking 60 the first day. But if you have all that paperwork, you shouldn't have.
You really have all the paperwork?
Yeah.
You do, okay. 'Cause we're gonna
But
make
like
it-
I say, he's
Not a
missing the
problem.
electrical and plumbing because he was short on money, so he
Right.
just paid.
Okay. Right, but 90 days sounds like okay, we're gonna close it out. Do you have anything else to add? Either one? No? Okay, so we're gonna close it out for your comments and then we're gonna make a decision. Okay, thank you. You're welcome. Okay, so we're gonna do 90 days and start a fine. A per day fine,
Yeah, you have to, because
$25.
that's the way it works.
Let's suggest a $50 daily fine, only because they did a lot of work without permit. Yeah. A lot of work. Okay, is somebody gonna,
Is that a motion?
I'm not gonna make it up. Somebody else make it.
I'll make it.
Go ahead.
I'll make it. 90 days to obtain a permit, if not, daily fine at $100 starts. Is that correct?
I think she said.
Did I say it right?
If you want $100, I said
No,
50,
that
but
way you
I said,
would mine.
I said 50 in mine, but I can do 100. The work was, there was a lot of work there. I second the motion at $100 a day fine after 90 days. And specifically, John, you want the permit to be issued, just to be clear, for the property owner.
All permits, how many permits are you applying for? I mean, you have one set of prints for everything? Okay, so you have a master. So you know a lot then.
She's a permit runner.
It's a permit, and then
Okay.
with.
Yeah, so there's only one permit for everything, so the master.
Yes,
If
they would
there's-
have some permits.
Well, I don't care about sub permits, Steve.
Yes, they'll have
The
one
building
master
permit,
permit.
right?
Yes.
Okay.
All right, so I seconded that motion.
I didn't know they had different contractors.
Well, they haven't submitted anything at the moment, so I don't know. This is the first time I find out how the rule is gonna be proceeding.
Well, either way, they have 90 days, and after the 90 days, if we vote upon it, there's gonna be a $100 big fine. So somebody needs to put some fire under it.
Okay, just to clarify, I have a motion by board member Bankston to grant 90 days to get the permit issued, or $100 a day fine will begin.
Correct.
That is
And I
correct.
have Jackie as a second, so I'm gonna take the roll call. Board member Figueira,
Aye.
board member Corey,
Aye.
board member Martinez Figueira,
Aye.
board member Bankston,
Aye.
board member Diaz,
Aye.
Chair Jimenez.
Aye.
Okay. So,
Thank you, Dave.
Thank you, thank you, you're very welcome.
Please keep me posted with any information. I guess we'll go in order now.
Yeah.
we can go to page one.
And what?
The first case,
The first,
And you can.
210 Long Way.
Okay, so
first case,
what,
Long
she
Way.
was a property manager?
She's a permit runner.
Permit runner.
She's a permit runner.
Permit runner, the company that's helping him with all his
He's the
permits.
owner?
He
He was
was
the
the
owner.
owner, she's doing all the permits and stuff for him.
The
And
owner-
basically rebuilt his.
The owner was the one that did not.
That I can't stand.
Who did the work?
We don't know.
Don't know.
The
I
whole
saw
thing.
one person working.
Unfortunately, we can't find them.
There's a handyman there.
Unbelievable.
What page are we on so far as documents? Of our little packet? What page are we on?
210 Long Way is page number 16.
16.
It's two,
Is
I'm not
this
gonna sell that house like that last one.
is this a picture of the circle?
you know, I thought about the same thing.
Yes.
Whatever
He's
happened,
gonna flip
Picture of
it,
the circle post, all the
He's gonna
changes of
flip
the
it.
circle?
Whatever happened. I saw the company name on it.
yeah. Why would he ever even buy it under a company name?
It's him and his wife under the company.
Okay,
Are we gonna be speaking about, so number one and number two, same property, same company
Yes.
owner?
case
Okay.
1 and case 2 is the same.
Understood. You found, I don't know, there are two cases on there, so I'm assuming you found something and then something else happened and you,
Yeah,
Okay, windows and doors.
so the first one is case number 20-1415. So 210 Long Way, code section 15104, application for building permit. On June the 12th, as I was doing my rounds, I observed, new windows and door installation without permit. I posted the civil infraction notice with 7 days to contact me. On, July the 14th, 2020, I posted and mailed the final civil infraction notice. On July the 24th, 2020, there was no contact, no permit, so a citation was posted at the property and also mailed via regular and certified return receipt. On July 29th, the $100 ticket was paid via credit card. And on August the 7th, 2020, still no permits, no contacts are reported to the local fine court. On August 21st, 2020, the summons Tokyo returned to police for service to the homeowner with copies of the summons mailed via regular and certified return receipt. So this is a photo of the house before. And after. So you can see it's all new windows, doors, with no permits on file.
So they live in Maryland.
Yes,
Is somebody occupying the house? Is it rented?
there's nobody there. I've never seen anybody there.
So it's empty, you think?
Yeah, as far as I know, it's empty. They're paying their fines. They are paying the tickets,
And where did you, by check,
credit card.
a credit card? So the property, the members of the LLC, somebody, a manager or something from the
Maryland.
LLC.
I would imagine, I don't know who makes, who's paying, because they're calling directly to finance to make the payment.
Okay, understood.
But other than that, they don't contact me, so I don't know what's going on.
And the lawn looks okay and.
Yeah.
Okay, no.
Okay. So, like I said, I haven't heard from them.
Okay, so there's been no permits, no nothing, we can talk about this case right now and make a recommendation and any recommendations?
I have an issue with people not showing up when there's something. And not even contact, not even phone call, nothing.
Email,
I don't have
There's every
any
possibility to get in contact with the city.
they can come to us, you know, Miami Springs, or in the web, they can call, talk to any of you guys. Huh?
Very hard for us, we're not gonna hold them.
It's hard to get a hold of you guys?
It's not.
Oh, I was
They are
gonna say,
available.
yes.
We're very available.
No, and everything's listed, emails and everything's listed.
From what I've experienced, we have one of the most available code enforcement departments that I have seen in my 20+ years of practice.
Okay, so,
Is the house for sale, by any chance?
Yes,
It is.
it is for sale.
okay.
I suggested
Yeah,
that
they
we
just
find,
flipped it. Yeah, they got it,
So they basically flipped it.
they did.
They bought it, they flipped it, and they,
And everything was done like pretty quick.
okay, so
Right,
they're,
Hey, so there's two cases?
There's two cases because then I got a call on the interior. The person called me,
This is for the same thing?
it's work without a permit, but this one, I saw it. No permit for the windows and doors. But then I get a phone call and say, hey, did you know that this house has been completely remodeled and there's photos, what's
Zillow?
that? Zillow, yeah. And I said, oh, no, I didn't know that. I mean, I have no way of knowing what's going on inside. So then
social
I
media
started-
kills you again.
I started investigating and, and you get more information, like,
Okay,
okay, but
so,
we'll handle that second case
Yeah.
when we get to the second case.
right.
I think we can talk about this one and make an immediate, suggested fine.
yeah, start it,
I would-
$50 a day.
I would start on that day that, let's see,
Let's
see.
Case like this, I mean,
$50 a day,
Huh? If he's selling it, we're just doing a flat penalty for it?
No, we're gonna do a daily and
it's
it's
a
gonna be
daily
like-
thing, and the people that buy it, it's gonna be a lien,
The lien
and
will-
they're gonna show when they come to buy
And
it,
they need
that
to
they
pay the-
own,
and they
you
need
know,
to pay the
$20,000 or
ticket.
$30,000, and they're gonna
Pay
have
the
to take
ticket.
care of that before.
Okay.
No, they paid the tickets.
They paid the ticket already,
Yeah.
okay.
Well, I guess Marilyn will show up at some time or
observation date to start a daily fine.
Upon a repeat,
I'm sorry?
upon a repeat offense, you can go back to the date that it was observed. As
Okay,
opposed to the date that it was
so
cited.
this would be the first offense, and we will discuss the second offense later. It will be a repeat offense. So here, we're limited again to $250 a day.
If it's a first time, yes.
Okay, so we're limited to $250 a day. My question is, I want to go back to the first, the code enforcement officer observed it on June 12th.
Then July
Yeah,
24th.
June 12th.
Because you gotta give them an opportunity to comply.
Okay,
I
so she
would go back to
posted,
July 14th.
okay, which was posted and mailed. We could even be a little bit more, on the day that they actually paid, apparently they paid by credit card.
7/24 is what I would use.
The posted ticket, I'm even okay with 7/29, which is the day that they paid.
Okay, that they paid it.
They're very on notice.
They
of this.
acknowledged it.
They acknowledged it,
Right, right,
I mean, they've gotten notice before, when the ticket was posted and mailed,
July
First
21st.
time offense is from the date that it was cited,
okay?
and then for repeat, it's from the date that the inspector observed the violation.
Okay, so we'll take care of the data that you learned of the violation, or whatever your documentation is on the second one. And it's gonna be whatever amount we can go up to depending on that. So here we're limited to $250 a day, and we're limited, as per the city attorney, the date that they were issued the ticket.
Yeah, yes.
I think we should just go by the date the ticket was paid,
Whichever.
which would be 7/29.
Yeah, it's already a month. So,
So whatever, of course, when they deem to be a violation, whatever those after those 7 days are, whatever that date is when the per diem fine starts to accrue.
The 24th of
So
July.
24th, the day,
Well,
if
you
we
know,
choose that.
if we do the 29th, it's easier for us to explain why we did the 29th. Because if we do the 24th, they can always say, oh, well, I didn't get
Yeah, we
notice
didn't
or
get it
whatever.
until.
But the 29th, they paid the ticket, so they know that something's wrong, so they should start on the 29th.
And that can be our choice.
Yeah,
So we started it.
they paid it, it's an admission of guilt.
So they acknowledge,
Yeah.
acknowledge.
They
their
acknowledge
problem.
it, they need the ticket, but in that ticket, apparently, they were provided 7 days, so they knew that as well.
So they paid the ticket before the
Because they
7
paid
days.
it, they admitted guilt, but they
Right.
never gave compliance.
Okay, so 7/29, I think it's a better date, and then we could discuss.
for the first case.
For the first case, we can discuss the maximum, is $250 a day.
Well, I wouldn't go to 250, but I would definitely do $50 a day, which is already $1,500 already at this point, or $2,000. Because they're gonna have another ticket too, inside and outside.
Well, there's another violation, so they deserve another jail.
What about if they already closed on this house?
I'm sorry,
What about if they already closed on this house?
the new buyers?
It's still missing.
I'm saying it, what about they closed on it today?
Well, normally they call me for reoccupancy unless, they sold cash.
You haven't gotten, the title agent needs that certificate of reoccupancy to close. They can't close without that.
I was just saying hypothetically.
Well, the only time
That
I
would be
see
our
that
problem.
is when it's a cash deal. If it's a cash deal, they don't
That's
have to get
different.
reoccupancy.
But they still need a reoccupancy.
Well, yeah, I
Once they,
think
once they file, they should be having a certificate of reoccupancy. But there's a change in ownership,
Yeah, but normally we catch it.
I can look up the address.
Until we get someone to make a motion?
210 Monway.
On the first one, I think, no less than $50 a day, starting on 7/29.
$50, you said?
Mm-hmm.
Like I say, I'm, you know, pet peeve of mine, you get a summons and you don't appear,
Well,
$50, I think.
consider it, they're gonna have another one too.
February 5th.
If you give them $50, they're gonna come for fine reduction anyway.
Property was sold on February 5th.
So if you give them $150, they're gonna ask for fine reduction, we're gonna go back to your $50.
go for it.
I'm just saying.
Yeah, yeah,
you know?
I mean, and we're the ones that,
And if they were here, it'd be a different story, but they're not even here, they don't even call they don't even call code enforcement, that, you know, all they did was pay the fine and acknowledge that they have a problem, but they really don't care.
What was your suggested number?
$150.
$150.
They did pull a permit for the roof.
Oh, but the roof, they knew they were gonna be seen.
Interesting.
Anybody
Okay,
else?
So you wanna start, you wanna give them
July
a
29th.
timeframe,
Retroactive July 29th.
if they don't get it.
No,
no,
no, no,
we start the fine already July 29th.
There's nobody
They
here.
acknowledge
There's nobody
that
here.
they-
to
Nobody here to
acknowledge
talk to
that.
us.
that they know that they have problems and that they have the situation that they fixed. They've changed the windows, they've changed the doors and everything. They're paying the ticket knowing that they're guilty. And that was on 7/29 when the money was received on payment on a credit card. So we're gonna start the fine on a daily basis from 7/29 on until
Until it's brought in.
Until they come into
until they come
compliance, and then
into permits and whatever else they need to do.
And then they can pay off the fine at the closing if they wanna sell the property, or they can come back and
So
speak to us.
It's not until they pull the permit, it's until they finalize the permit.
Well, I think when they pull a permit,
Yeah, once the
because
permit
it's
is
already
issued.
done, it's already done.
No, I know, but, you know, they still have to pull
So
a
they get the
permit.
permit, they gotta get the permit that fast,
Well, that's not our problem. They should be here speaking to us.
until the permit is issued. Or you want to be compliant. Compliance is a permit, right?
Well, that's up to you on how you wanna do it. Either a permit issued, and we'll stop the fine once the permit is issued.
Well, you,
And if the
if you do
permit
it till they come
expires,
under compliance, then that's gonna be a while, take them all.
I think it should be until the permit is issued.
I mean, they're gonna be paying by the,
yeah, because once they have the permit, they have 6 months at least to close it out, you know. And now if the permit were to expire, then I
Then
don't
you
know,
can come back
we
to
can
us.
always revisit.
whatever.
You observed the windows on the back and the side were replaced as well, or just the?
Yeah, there was some in the back as well.
Or some in the back?
There were quite a few.
Yeah. I mean, this is, you know, maybe $15,000-$20,000 worth of windows. So, wow, yeah. If we do $15 or $150, it's been 3 times $4,500 roughly already. And then they still need to do drawings, submit for permits, which is probably, if they even respond, it's probably 60 days out. So, I mean, they're gonna pay for, 50% of the windows just in fees.
Not our problem.
I'm okay with George's, $150 a day, and July 29th beginning, and let the fine continue until the permit is issued.
Okay, George, make
Make
the
your
motion
motion.
and then somebody can.
See if we get a second.
I make a motion that we fine the property $150 for the owner, $150 a day, retroactively to July 29th. Until they until they obtain permit for the work they've done.
Permit is issued.
An issued permit.
Until the permit is issued.
Right.
Need a second?
I'll say.
Okay, we'll take a roll. Board Member Figueira.
Aye.
Board Member Corey.
Aye.
Board Member Martinez Aguirre.
Aye.
Board Member Bangston.
Aye.
Board Member Diaz.
Aye.
Chair Jimenez.
Aye.
Okay. Thanks. Next one.
They haven't paid the second ticket, right?
Yes, they did.
They did?
This second case, as the city attorney mentioned, is a repeat offender. So what is,
$500.
I don't know, would that be considered a repeat?
I'll read the definition of a repeat. It's a violation of a provision of the city code by a person who has been previously found by a code compliance board to have violated or who has admitted violating the same city code provision within 5 years prior to the violation.
the same, so
Not-
we need to see what the ticket is, is it the same application for permit?
Yes.
Yes,
It's the same
they're
to
both.
me.
same within 5 years?
We just,
Easy.
yeah, we just issue, keep it the same. And it's the same, it's a repeat.
So now you go to 500.
So, thank you for that clarification.
And
Really?
it's
When
from
was
the
it
date that the violation was witnessed,
Was observed.
observed.
Go ahead, Mary.
Okay, so this is case number 20-1762, 210 Long Way, code section 15104.
What page are we on in the packet?
30.
Okay. 30? 30.
Was the verbiage part. So on July 24th, as per complaint, I did observe some flooring. They had mentioned to me that the whole house had been remodeled, so I put possible kitchen and not been remodeled. So on 7/27, I posted and I mailed the civil infraction notice. On August 21st, 2020, no contact. I posted a $100 ticket number 549 at the property, also mailed regular and certified return receipt. On August 21st, August 21st, 2020, still no permits, no contacts, I referred it to the code compliance board. And on the same day, Clarence Scorpio was sent to police for service, the homeowner. Copies were also mailed via regular and certified return receipt. And yesterday, the $100 ticket was paid via credit card.
On August the 31st?
Yes.
Okay. Because that's
So
not
we
in
need,
our,
so, okay.
that's not in our notes, right?
No,
Okay.
bingo.
But we can go back all the way to the observation, which would be, I don't know about observation, but
I think it should be the payment again.
I'll say, as for the thing you observed, new flooring tiles, you did.
I happened to see the flooring because, this window here was open.
Okay.
But then, there's a posting.
Okay.
And this is a photo that I had from before, showing that there's the kitchen and the house was, an old home, and
And where did you get those photos from?
I took them.
The old ones, you took.
I took them.
Okay.
Yes.
You were
And
given
this is
access to the property.
Kitchen, yes.
Okay, go ahead. This was the old kitchen?
The old kitchen.
And how were you in there? This is all related to the first matter.
This was, no, reoccupancy.
Understood, okay.
Okay.
Okay. For the sales.
On reoccupancy.
Okay.
Yeah. We usually take pictures of the kitchen, all the outside and, including the trees, and if there's any garages, we take photos of that.
Yeah, question, are we allowed to use the Zillow posting for information? Because it's like, I just checked on my phone, and it's crazy.
Yeah,
They read it all.
Look at it.
They just.
Very nice.
It's-
Nice work.
Yeah, I double
The
checked.
short answer is yes. Yes,
Wow.
the evidence is admissible.
Okay.
That is.
So there's a
nice.
big difference, yeah. There's everything.
Yeah.
There's the address, that's how much they're selling it for.
Okay.
Wow.
So,
Super nice.
and there's, the kitchen and the bathroom. What they had told me, the person.
Talk about convicted yourself.
What was that?
Okay, so
Idiot.
going back to July 24th, you observed was the day that you were able to look.
Yeah, that's the day that I happened to, that I was able to see the floor, and with us, if you replace your entire floor, it requires a city comment.
Okay, so we can confirm with the Zillow photos that there is in fact,
That there was
major remodeling going on.
kitchen
Without permit.
and bath remodeling.
Yeah, she's got January,
Yeah, she has
Right.
in January, and we have the,
the occupancy is perfect.
and so we can actually go all the way back to July
Read
24th.
police work.
If we wish, or we can keep it the same, or we can do August the 31st without. When they pay, but they obviously have been doing things way before.
Okay, so this motion's gonna, be for the same amount of money, or
Yeah. We can go up to 500.
it's
That's
gonna
like an
start
advance.
8/31?
I think we should keep it, let's do both of them the same, although we can go
Yeah.
further back, let's keep it at 831.
I think 831 is good.
And we're gonna increase the fee, it's not gonna be $150.
8:31.
831.
August 31st is when they pay,
Okay,
so we're
yeah.
gonna start it there. It should be
So they acknowledge,
250 at least.
that's what we went by on the other one. But they acknowledged that a month ago, almost 5 weeks ago.
Okay, this is the second of mine,
Audrey
so,
suggested a $250 daily fine, and I think if we're okay with the 831 date.
So you want your first one?
First motion.
Your first motion? All right, all right.
That's how it goes.
Go for it.
All right.
So you got the date?
I motion,
8:31.
to, I guess, levy a $250 per day fine starting on 8/31/2020,
To come under
to
compliance.
come under compliance with a permit issuance.
The state has with building permit? The
Sorry?
other one?
The building-
All permit is issued?
Permit is issued.
Permit is
A building
issued.
permit is issued, until a building permit is issued.
I'll second it.
Take the roll. Board Member Vergara,
Aye.
Board Member Corey,
Aye.
Board Member Martinez Rivera,
Aye.
Board Member Bangston.
Aye.
Board Member Diaz,
Aye.
Chair Jimenez.
Aye. $400 a day. Unbelievable, that sign, oh my God. Okay, anything else, you guys?
The next one is, yeah.
This one.
One more.
East Drive, yeah, what page?
42.
Thank you.
So this is case number 20-567 at 214 Glendale Drive. Code section 15104, same application for building permit. So on December the 12th, 2019, I observed new flooring, drywall, and what looked like recessed lighting, all done without permits. I explained to the gentleman that a permit was required. He kept telling me, no, I don't need a permit for this, but I told him he did, so I said, well, I suggest you contact the building department, so that's what he was gonna do, he was gonna contact the building official. So on February the 7th, 2020, no response, no permit. I mailed zero question notice to the homeowner with 7 days to comply with permit. On February the 2nd, 2020, I spoke with Mr. Eric Argote via phone. He claims to have just changed a couple of floorboards and drywall, and he was telling me he was going to meet again with the building official to determine if a permit was required. On July the 7th, 2020, construction debris was observed in the alley. There was some drywall with other items. They had pulled the windows and door permit, number 20-598, which was finalized on July the 1st, 2020. Permit for interior remodeling still not issued. Permit is required as per building official Ulysses Fernandez. So on 7/9/2020, a $100 ticket number 01679 was mailed via regular and certified mail, not posted at the property due to the COVID-19. On July the 13th, 2020, I texted Eric Argote with the photo depicting interior work done. August 5th, 2020, still no permit, ticket not paid, so I referred it to the code compliance board. On August 21st, 2020, summons was here with Jersey Police for service to homeowner with copies of the summons mailed via regular and certified return receipt. On August 21st, 2020, summons to appear was served to Eric Argote at property by Officer Castellano, badge number 0212, and returned to myself on August 25th. On August the 26th, 2020, Officer Quintero received a phone call from Eric Argote on behalf of Michaelita Martin. He explained that they would not be able to attend the co-compliance board meeting because they were COVID positive. So that is the reason they are not here.
A good excuse.
And there's the photo that I have.
Dangerously close to trespassing there. Dangerously close to trespassing. Were you on the?
No, I was
property
at the
area?
front door. The door was open.
Okay.
I was actually there for something else. I was there for their pot. because they had applied without a permit. So I went to talk to him about that, and I saw that.
So that's not considered a second offense because it's not the same thing, correct, city attorney? Because it has to be the same violation.
It has to be
on
the same
property,
provision of the
individual.
code.
Same individual, same violation.
But this
Yeah,
is a
it could
different
be
case.
different property, like.
It could be a different, but the same name, okay.
Yeah.
Do they have other violations, this property owner?
Did they get something for the pod or nothing?
Yeah, they pulled a permit for the pod.
Okay.
Right, but this is a different violation from the pod, so it would have to be,
Yeah,
I think from what you read, it has to be the same violation, same owner.
yeah, yes,
So these are two different violation, types of
Yeah.
violations.
yes.
They will have to
And
come
they,
to
and
the
they
board.
have to come in front of the board, so it's the first time they can get provided in front of the board.
An adjudication, right, so if they, yeah,
It's the first time.
Yeah, it looks kind of close, but it was actually, I was at the front door and the door was open, so I took a picture. And there's the gentleman right there. I don't know if you can see him.
Yeah. He's hiding.
Okay, so, and we can go back to the date that the ticket was handed out, which was 7/9. We were to start fine on a daily basis.
the date,
This is just to go back, this has been going on since December.
the ticket gives a grace period, whatever it is after that grace period. I don't know.
I know that they got the
7
ticket
days.
in July, but they've had plenty of notice that, you know, we were on the,
Well,
And these are
7
the
months
photos
from
of the debris, the
December.
construction debris in the alley. Actually, Public Works called me because they wouldn't pick it up.
right,
So,
people are not so bright.
yeah, okay. So I would make a suggestion that we go all the way back to 7/9 with a daily fine.
what was the ticket issue?
7/9 when they issued
2020,
the
day
ticket.
Ticket was issued, keeping into account that this has been going on for a while.
They didn't show up.
So 7 days after 7/9.
Yeah, exactly.
As rules.
And look at the date, the date, we can make it show it.
What, we're gonna make them give us our thing?
Yeah, and we should have their COVID report.
So we'll look at the,
Yeah, they
so I
can
can-
The ticket is on page
Definitely.
57.
I agree, when I read it, I was
First
like,
thing, 7 days to produce positive testing for
Yeah,
both of them.
July 16th.
Okay, so that's what I want, so July 16th is when we will, it should have been in compliance.
Yeah, 7 days after,
Right,
right?
there you go.
So July 15th,
16.
16?
16, yes. So, we'll go from there.
John, you mentioned.
I was questioning the COVID positive thing, which is an excuse not to come unless they can come up with some paperwork that says that they are COVID positive. And I'm sure you get one.
I don't know.
So asking for, kind of like they open the door, they're gonna use COVID as an excuse for like, to back it up. That's my take on it.
For what?
It's not like, it's not like anything like HIPAA, right? We're not requesting medical records. If they say, hey, by the way, I have COVID, I got COVID, I can't show up. My position is, okay, well, you must have gotten tested, right? You show us.
Right.
show-
And you get some type of paperwork or message.
Yeah,
You just show your setup.
yeah, that could be, didn't get tested.
Well, I don't wanna get into violations of, HIPAA violations and anything like that, which we may or may not be touching
I'm
on.
just saying, you
Yeah,
And I'm just saying,
find it and they, that we didn't come, I mean, they would have to show it.
there's nothing in our ordinance that says we have to excuse anybody because they didn't show up, or reduce our fine, or not put a
I'm saying
fine in
they
them.
couldn't come to the meeting because of the same stuff. So if they came to the meeting, they were gonna ask us for time, and we gave them time.
That's true, and we can.
No, I'm just saying if we make the order or whatever,
yeah.
we may be faced with that. We're just asking, we may be faced with, hey, okay, you gotta prove it to us, right?
I don't.
That's fine, if we can, if we're gonna use that.
It's gotta be in an email,
Yeah,
they're gonna have it with them.
they may be a search, right, exactly, that's,
But I don't know about them producing medical records, is what I'm It's not medical record,
It's not.
it's just,
It's the tape how we get into the schools to talk with it, it's all of us out.
it's just an email. Just to protect what we were trying to accomplish here, I would give them a time period, and then if they don't have a permit issue after that particular time period, you start the fine, just to avoid everything
So you're
regardless,
gonna give them time.
if you want.
No,
Because
that's not what I want, I'm just bringing up a question of,
everything else that you mentioned to me bothers me. That the, you know, the staff would have to worry about getting any information on testing or anything like that. That's a little touchy for me. Why? It's just, and you get it in an email, all they have to do is produce, hey, look, would they give me that information if you took the test? Or is that private information?
Oh, no, this is, well, I need your reading because it's HIPAA.
Correct.
Right. No, we're not requesting, the medical records.
Who's to
My
say,
understanding
who's to
is-
say that a test result, whether you're positive or not, is not a HIPAA-related document?
he's
That's
telling
why-
us that he got it.
Well, yeah, that's,
Telling us
they're
he has it.
disclosing it, they're
So
disclosing.
he says I have it, okay, show us you have it.
That's
But
just my.
we can avoid that. We can give them a time period to
Yeah,
come
you
into
can avoid it.
compliance, and then we can start the fine afterwards if they don't. We could avoid all of that. I just think they're using it as an excuse that doesn't exist, and they're not here. It's a lot of people that don't show up to these
Okay,
meetings,
make
just
the
like
motion.
George, he
It'll be
gets
the last one of the
upset.
night, if you do it right. It'll be the last
It's a
one.
good issue.
How much time do you wanna give them, if any?
No, I mean,
I would not give them more than 30 days.
I mean, he hasn't commented, you know.
Since December of last year. I actually
Doing
want,
this shit.
I actually
9
want
months.
7/16/20. I don't even wanna take into account that, any comments about. He's been working on this house since last December. That's correct. He knows, they've been on notice, he knows.
And
He's
they
been
knew
told.
They knew since December that they needed a permit, so according here, it said, explain that permit was required.
Right, and he said no.
So you spoke to somebody at the property on December 12th.
Yes. Again, this
I
is
spoke
the-
to that gentleman that you saw there. You can't really see him, but he's there.
Has he been responsive? Is that the homeowner doing the work or?
The homeowner is a lady, I don't know who he is. He was there, I would imagine, doing the work, but that's Eric Argote.
That's Eric Arluda?
Yes.
And he's.
That's the one that I've been talking
Okay,
to,
how
but
many
the
days do we
homeowner
give him?
is
Give him a permit.
Margarita Martin. So I'm not sure
I
who
don't
he
think
is.
he
And on
should
the
give
on the
very
12th,
much
did you
time.
speak to Eric Argote?
I'm sorry?
On the 12th, did you speak to Eric Argote?
Yeah.
I don't wanna give him any.
Yes, I spoke to him.
But he's not the owner of the property.
No,
So basically, he could have not relayed the information to you. He could have just
30 days.
let it
out.
by
If
and
there's
continued
anything
work.
more than 30 days.
I,
I'm
but
just-
I sent a note, I sent a ticket, I sent a notice to the address
Right.
that shows to her. So she has to be aware, and, oh, and he didn't he mention that him and his wife were sick with COVID? So I don't know, maybe she is the wife, I don't know. I'm not sure.
I mean, I would be inclined to give him just a 30-day
30-day
notice that you're in
Start
violation. And if he's not the owner or not relaying this information, at least now they would know. And then hit the fine stuff.
I'm not worried about this. Eric Argote is the worker or the contractor?
I don't know who he is.
Okay, I'm not worried about him.
He was the gentleman there.
Right, and the problem is that we have zero communication with the property owner.
Well,
it's a runway partners. It's LLC. Right, you know, these are usually.
Well, he says that he changed the floorboards.
No, I think you're looking at the wrong agenda.
No, the owner, Margarita.
Margarita.
Margarita Martin.
Market 56 East Drive, and they're
It
not
looks,
looking at.
maybe, you may get confused with the previous case, John. We're on page 43.
Well, he put the wrong case.
Yeah, February the tenth.
Case number 3.
He mentioned to me that he had changed the floorboards and drywall.
This is
Page
not owned by
43.
a corporation, it's owned by.
By three.
By Margarita Martinez.
Margarita and Margarita Martin.
Okay, who's the owner?
Margarita Martinez.
An individual.
Yes, okay. Page 57 shows a copy of the citation
Okay.
and the property owner information.
There's no entity, it is an individual.
It's an individual, Margarita and Margarita.
He's saying that they both have code.
Yes.
Well, I really don't
Him
care
and his
about
wife
Eric
were arguing.
Well, he's saying that both of them do.
I understand that, so we're giving them,
I'm just saying, he's mentioning his name and her name, and they are code they.
that's fine, that's why we're giving them the
Okay,
courtesy
so-
30 days.
So we're gonna start, we're gonna give them how much time?
30 days.
30, they can't get it 30, just so you know.
Well, they can attempt to come in and acknowledge, and then they can go from there.
Okay, so then we're gonna make it retroactive back to 7/15,
7/16.
okay, for $50 a day, is that good enough?
What did they do? Flooring, drywall, recessed lighting.
Yeah, I think it's not that.
Is that all right?
Like 7:15.
Well, that's all I
7/16.
observed. I don't know if you did anything else.
But that's the,
They won't be able to do it 30 days, so you know.
how much time?
To the building department right now.
Yeah.
Okay, so
We asked,
60 days?
60 days?
60, I'm just saying, they won't do it in 30.
Okay, 60 days, $50 a day,
60,
60 days at $50 a day.
7/15/20.
That's how much it is.
Retroactive.
Retro has to be 7/16, I believe, the state.
7/16?
Yeah.
That was 14 days after July the 9th.
I got any glasses, I got any
Record here,
hearing
about
aids.
that.
Okay, I'm gonna make a motion.
Was I right?
for-
Hold on, George has a comment?
Oh, you can do it.
You're saying the date 7/15, but I don't see anything.
No,
No, there's
because
nothing
it's
on
7
there,
days
but I'm saying it's
after.
the 16th, 14 days after July the 9th is how many days? Is
No,
what day?
7 days
Oh,
after
7
the
days
9th.
after July 9th.
It's a
You have to give
period.
them 7 days to.
See it, George?
In the middle, it
Yeah,
says
seven-
on
seven-
7/9, and you add 7 days, so
We-
7/16.
We asked for the date, it's not okay.
I can amend.
Okay, I'm gonna make a motion to give the owners
16.
60 days to obtain a permit for the said violations. And if not, it's $50 a day fine, and it will start on 7/16/20.
Retroactive.
Go backwards, retroactive, whatever you call
do I have a second?
Second.
And it's a permit issuance as well.
it. Permit issued for all violations.
Can I take a roll? Board Member Figueira?
Aye.
Board Member Corey?
Aye.
Board Member Martinez Figueira?
Aye.
Board Member Bangston?
Aye.
Board Member Diaz?
Aye.
Chair Jimenez?
Aye.
What's the fine?
What was the amount of fine on that one?
$50.
50.
$50 retroactive July 16th. You have any other pending cases? Nothing? So we're gonna call this
Oh my
code,
gosh, they need to bring your, oh no, we can't have it.
call this code enforcement.
Because we'll clean it up, we'll disinfect it every time. Thank you for the
Thank
food
you.
there. Thank you.
Thank you up there.
Thank you.
Thank you.
Have a good night, everybody.